We are back with part 3. If you guys have not watched the other videos, please go and watch the other ones, or I guess watch them in whatever order you want. I take these words and I scatter them through time, for I am the bad wolf. What's up, guys? As always, thank you. Thank you in advance. This is your first time here. Welcome to the tribe. Please subscribe. We're going to be talking about municipal regulations in concerns to right to travel. With that being said, we're just going to jump right in. I appreciate each and every one of you guys. Let's take a look. Oh, it is not queued up. I apologize. Give me one moment. Doobie doobie doo. Do 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 do. Ah, there we go. All right. Hopefully everybody's doing good out there. I wish you guys positive light and energy, thoughts, mental health, and financial success. May no weapon formed against you prosper, nor any person. That being the case, let's get going.
Municipal regulation. The courts are duty-bound to recognize and stop the stealthy encroachments which have been made upon the citizen's right to travel and to his personal, private use of the roads. Hadfield, Supra. Further, the court must recognize that the right to travel is part of the liberty of which a citizen cannot be deprived without specific cause and without the due process of law guaranteed in the Fifth Amendment. Kent, Supra. In general, municipal corporations possess no power to encroach on individual rights unless such authority is plainly conferred by the city charter or other law, and municipal ordinances ordinarily should not contravene those principles of common right which are embodied in the common law. Ferron v. City of Palo Alto, 50 calories, App. 2D 374, 122 p.2d 965. 1942, McKelly v. City of Murfreesboro, 162 Tennessee 304. It is the duty of the court to recognize the substance of things and not the mere form. The courts are not bound by mere form, nor are they to be misled by mere pretenses. They are at liberty indeed, they are under a solemn duty to look at the substance of things, whenever they enter upon the inquiry whether the legislature has transcended the limits of its authority. If, therefore, a statute purported to have been enacted to protect the public safety has no real or substantial relation to those objects or is a palpable invasion of rights secured by the fundamental law, it is the duty of the courts to so adjudge, and thereby give effect to the Constitution. Mugler v. Kansas 123 U.S. 623, 661. A municipality has no authority, subsequently no jurisdiction, to prosecute claims of a commercial nature against private citizens not commercially engaged. More because the highways passing through a city are extensions of highways preemptively regulated by state and federal laws. When the state chooses to regulate and act under its police power, its laws and operations predominate over the local laws and ordinances. Municipalities may not adopt ordinances that are inconsistent with state law. A state statute which preempts a field precludes local agency or government legislation on the subject. 56 AM Jure 2D Municipal Corporations Section 391. See also Allinger v. Bennett 562 NW 2D 167. Thomas v. State 614 So 2D 468. A city may not attempt to regulate beyond its jurisdiction.
Whoa!
City of East Lansing v. Yucca 142 Michigan App 491, 369 NW 2D 918. The focal point of this question of police power and due process must balance upon the point of making the public highways a safe place for the public to travel. A local municipality may induce reasonable regulations, for instance when a person could block a portion of road for a parade, or erect barriers to protect the public from a sinkhole or designate certain portions of road for public parking. A municipality may impose other regulations adapted to its own peculiar conditions if they are not inconsistent with those of the general character prescribed by the state. AM Jure 2D Automobiles Section 20. Municipalities retain considerable authority to regulate how motor vehicles engaged in interstate commerce shall be operated over their streets and may require that such vehicles obey traffic and other general safety regulations. AM Jure 2D Automobiles Section 29, citing City of Chicago v. Atchison, T. and S. Zeph. Re. Company 357 U.S. 77, 78 SCT 1063. On the other hand, a municipal regulation is not necessarily rendered invalid by the mere fact that private rights are subjected to restraint or that loss will result to individuals from its enforcement. This is more to parking enforcement, for instance. Dennis v. Village of Tonka Bay, 156 F.2d 672, CCA 8 THCIR. 1946, Downey v. Sioux City, 208 Iowa 1273, 227 NW 125, 1929, City of Butte v. Paltrovich, 30 Montana 18, 75 p. 521, 1904, Soloff v. City of Chattanooga, 180 Tennessee 296, 176 S.W.2d 816, 1944, Harper v. City of Wichita Falls, 105 S.W.2d 743, Texas Civ Tap, Fort Worth, 1937. As long as municipal bodies confine their enactments within the proper limits of their police power, they do not unlawfully violate the private rights of the individual. Remen v. City of Des Moines, 200 Iowa 286, 204 NW 267, 40 ALR 922, 1925, Willoit v. City of Springfield, 237 MO App. 775,171 S.W.2d, 95, 1943, Harper v. City of Wichita Falls, 105.W.2d 743, Texas Civ. APA Fort Worth 1937, writ refused. These next few pages tell of municipal regulation and municipal authority from a myriad legal resource, which need no further narration on the part of this writer as they are substantially clear on municipal abatement. As much as these judicial decisions and legal resources further explicate the breadth of this writing, the length of the citations remain to show judicial and legal consistency. However, the municipal police power must be so exercised as not to infringe arbitrarily or unreasonably on private rights. Of Mary 11 v. City of Wheaton, 379 IL 504, 41 N.E.2d 508, 1942, Downey v. Sioux City, 208 Iowa 1273, 227 NW 125, 1929, City of New Orleans v. Southern Auto Wreckers, 193 La 895,192 So. 523, 1939, Farrell v. City. Syracuse, 137 Miscellaneous, 472, NYS 316, Sup. CT 1930, Harper v. City of Wichita Falls, S.W.2d 743, Texas Civ Tap, Fort Worth 1937, writ refused. Whether they are personal rights or property rights. Jello Company v. Brown, 3F, Sup. 132, W.D. Washington 1926, Miami Shores Village vs. W.M. Brockway Post No. 124 of American Legion, 156 Ha. 673, 24 So. 2D33, 1945, City of New Orleans vs. Southern Auto Wreckers, 193 La 895,192 So. 523, 1939. The standard for evaluating ordinances claimed to be violative of due process or equal protection is whether a rational basis exists for the police power exercised or classification established by the ordinance. Autotronic Systems Incorporated v. City of Coeur d'Alene. 527 F.2d 106, 9th Circle 1975. Local police power enactments must not interfere with private rights beyond necessities of the situation. Houseman v. Dayton, 73, Ohio Street 3D 671, 653N.E.2 D 1190, 1995, reconsideration denied, 74, Ohio Street 3D 1423, 655N.E.2 D 742, 1995, and distinguished by State ex rel. Ohio Academy of Trial Lawyers v. Sheward, 86, Ohio Street 3D 451, 715N.E.2 D 1062, 1999, Pretty v. City of Tulsa, 1994, OK County Route 63, 881P.2 D 81, Oklahoma CRIM App, 1994. Any interference with the protected rights of the citizens of the municipality must bear a reasonable relationship to the public needs served. Metropolitan-Dade County Fair Housing and Employment Appeals BD v. Sunrise Village Mobile Home Park, Inc., 511 So. 2D 962, Flaw 1987, Pretty v. City of Tulsa, 1994, OK County Route 63, 882P.2 D 81 Oklahoma CRIM App, 1994, Tidewater Association of Homebuilders Incorporated v. City of Virginia Beach, 241 Virginia 114, 400S.E.2 D 523, 1991. The police power does not justify an interference with the citizens' constitutional rights that is entirely out of proportion to any benefit redounding to the public. City of Baton Rouge v. Williams 661 So. 2D 445, Law 1995. Municipalities must not exercise their extensive regulatory powers in an arbitrary or discriminatory manner. Nice v. City of Johnson City, 767S.W.2 D 638, Tennessee 1989. It is not within the power of a municipal corporation to make a particular use of property which, in the absence of legislation, is lawful but which is of such a character that it may be regulated or controlled by public authority, conditional upon the assent or permission of private persons. When an ordinance thus attempts to confer power on some property holders virtually to control and dispose of the property rights of others, and creates no standard by which the power thus given is to be exercised, so that the property holders who desire and have the authority to establish the regulations may do so solely for their own interests, or even capriciously, constitutional limits have been violated. 56 AM June 2D Municipal Corporations etc., Section 400, Cites omitted. A municipal ordinance which commits the exertion of the police power to the option of individuals to determine whether the use of property for a purely lawful purpose offends the health, safety, or welfare and violates the fundamental principles of the police power. Appeal of Perrin, 305 Pascals, 42, 156A, 305, 79 ALR 912, 1931. As a general rule, the owner of private property is entitled to the enjoyment thereof free from municipal interference. However, a municipal corporation in the exercise of its police power may make regulations with respect to property within its borders provided the regulations are reasonable and bear a substantial relation to the preservation of the public health, safety, morals, or welfare. Teglund, below. In general, and except insofar as concerns the exercise by a municipality of its police powers, the owner of private property, located within the municipal boundaries, may use it for any lawful purpose or in any lawful manner that he may see fit.
Did you hear that? Did you hear that? In general and except insofar as concerns the exercise by municipality of its powers, police powers, comma, the owner of private property located within the municipal boundaries. So what they're saying here, and well, all I'm going to say is to the person who mentioned they didn't like me doing commentary in my own video on my channel. Yeah, I don't really care because you need to understand these things, but I guess you don't. So, ta-ta. To the rest of the people, I appreciate you guys. You have to understand what's really going on here, not just reading it, because this makes it sound like it's all the same. It's not. They're saying that these municipalities have police powers, but you have your own property that's private, your vehicle, yourself, your house, that is located within the boundaries of the municipal. What does that really mean? That means that all right, break screen. Shows, that means that in the geographical area known as California, California Republic, that is land. We, the Republic, Californians, own the land. California state. Okay. And the municipality, they're right here. They're on our land doing business, but they don't own the land. They govern only those people in the area who identify themselves with their, well, I'm not going to really say color, but their hallmarks, which are driver's license. You've registered your name to them. You've registered your vehicle to them. You've registered your car, your house, whatever to them. But that still does not give them complete control over you. Just some. Constitution and your private rights, faith, religion, all that still are yours. You plug into each one of these things when you're wearing and rocking their colors and their stuff. The moment you go private, purple for majestic or royalty, red for the national state citizen, they can't see you. Where do those people go? Because you're private. But the reason why they attempt to still see you is because you haven't rebutted their assumptions that, well, it's still you, right? Right. No, we're not wearing orange. Well, I mean, we still have jurisdiction over you. No, you don't. We're under the Constitution, God, faith, religion, private law. We're actually your boss. Oh, okay, easy, whatever, stupid, sovereign. But the reason why they can still try to do that is because your name that's on everything, you're using the one name that was your private name, your given name. You and your parents registered to them. So when they address you and you respond to that, and all of your IDs say that, well, show me who you are with one of the IDs that we gave you a long time ago based on information that you gave us. That is you, or are you attempting to do something fraudulent? It's not fraudulent to have more than one name, but not more than one name in the same system. Your name has become tainted, so the system, not the land, the municipality above the ground, sharing the same geographical area, but they don't own it all. They only own an invisible overlay, like you resonate with them. Everything else passes through, can't be seen. So they can't see you when you're like this, but that's because you don't have a private name or a separated straw man name from your real name. Okay, which is what we've been talking about, officially separating the straw man. I haven't seen anybody do it yet. We're working on it. We've got things in place. It's going to take some time. Let's try to get it mastered, all the bugs out and everything. So with that being the case, even though you have this is who you truly are, or you guys are, they only see you as this. Hey, high five. So you are a private person who's given up your identity to them to be regarded as always their property unless they do significant damage to you or break your rights, and then you go take them to the federal court and come back as this. The federal court's going to say, well, are you exercising any of those things, those freedom, those benefits and privileges? Well, I mean, yeah, we like to drive, so federal court's going to say, or Supreme Court's going to say, well, then That's your fault, unless you can prove that they've denied you of your rights, your freedoms. But while you're enjoying their benefits and privileges, you don't get those protections. You are just their janitor. So you go from being down here, janitor, their employee, but you can be up here subservient and overstand them if you know what's going on. If you don't know what's going on, then you're just property. And that's how you're going to be utilized and looked at, referred to, treated for legal reasons. When you go back to being in your red and purple status, or standing rather, excuse me, as the red blood of the red ruddy male on which the soil you stand, and the blood of which is red, purple being majestic. If you do that, then you go back to being on the land. Remember, they're maritime, water jurisdiction. Land beats water, but not if you're enjoying swimming in it. If you're trying to get out, you're trying to do something else, you're trying to get actually on a boat, your own boat, and trying to get to land, then they're like, well, you better do it right. Otherwise, you're in the water and it's shark infested, player. Let's get back to it.
Teglund versus Dodge, 316 Michigan 185, 25N.W.2D 161, 1946. Tillotson versus City Council of City of Cranston, 61 RI 293, 200A.767, 1938. A municipal corporation may not interfere with such right. Benner versus Tribbett, 190 MD6, 57A.2D 346, 1948, Town of Clinton v. Ross 226 NC 682, 40S.E.2D 59, 1946. But unless or until harm or damage, a crime, is committed, there is no cause for interference in the private affairs or actions of a citizen. 56 AM Jure 2D Municipal Corporations, etc., Section 396 ET Seek. Municipal police regulations must also operate in a manner that is not arbitrary, oppressive, or fraudulent. City of Russellville vs. Vulcan Materials Company, 382 So. 2D 525, ALA 1980, Wilson vs. City of Cincinnati, 46, Ohio Street 2D 138, 75 Ohio Op 2D 190, 346N.E.2D 666, 1976, Wright vs. Woodridge Lake Sewer DST, 218 Con 144, 588A.2D 176, 1991. Municipalities may enact ordinances pursuant to their police power, subject to constitutional limitation that they be not arbitrary or capricious. 515 Associates vs. City of Newark, 132 NJ 180, 623A.2D 1366, 1993. The police power exercised by localities is subordinate to the equal protection and other guarantees of the federal and state constitutions. Hicklin vs. Orbeck, 565 P.2D 159, Alaska 1977, probable jurisdiction noted, 434 U.S. 919, 98S, CT 391, 54L, ed. 2D 275, 1977, Town of Atlantic Beach vs. Young, 307 N.C.422, 298S.E.2D 686, 1983, appeal dismissed, 462 U.S. 1101, 103S, CT 2446, 77L, ed. 2D 1328, 1983. As a short corollary, saving exciting discussion, see section on anatomy of a traffic infraction. At 56 AM Jure 2D Municipal Corporations, etc., section 396 above, the question of harm is raised. The question or statement of harm raises, in a criminal context, the rule of corpus delicti. The rule of corpus delicti demands that the crier show proof that some actual injury has been sustained. So, the question begs, in a criminal traffic prosecution against the unaware traveler who thinks a license is mandatory, what exactly was the loss incurred by the crier? State. Immediately there are only two suspect yet undisclosed potential losses. 1. Loss of revenue. 2. Failure to maintain the business in conformance with state policy mandate. More to the point, corpus delicti, in a legislative context, means an injury malum prohibitum, which means violation of a legislated policy, i.e. loss of interest. It does not import actual physical loss. The whole ACT rule. And expressio unius est exclusio alterius. This chapter is dedicated to the summation that all law supports all law. It does not matter the type of law, commercial, civil, criminal, common, or tort. All law is somehow and somewhere dependent on other forms of law. For instance, criminal trespass lends itself to civil tort. Maritime law lends itself to commercial trade. While this writing is prejudiced to common law travel, constructive rules of law still apply. The whole Act rule is based in part on these two Latin maxims of law. Optimus interpret andi modus est sic legis interpretar ut legis legibus accordant. The best mode of interpreting laws is to make laws agree with laws. Optima statuti interpretatrix est, omnibus particulus justum inspectus, ipsum studum. The best interpreter of a statute is, when all the separate parts of it have been considered, the statute itself. The basic introduction to the whole Act rule is stated thus. Statutes in pari materia must be construed together. Statutes in pari materia are those which relate to the same person or thing, or the same class of persons or things, and in construing a statute, or statutes, all acts relating to the same subject matter of having the same purpose, should be read in connection therewith as together constituting one law. The object of the rule is to ascertain and carry into effect the intent of the legislature, and it proceeds upon the supposition that the several statutes having to do with related subject matters were governed by one spirit or policy, and were intended to be consistent and harmonious in their several parts and provisions. Emphasis. Mine. State v. Houck 32 WN 2D 681, citing State ex rel. American Piano Company v. Superior Court, 105 Washington 676, 178 Pac.827, Paltrow v. Aetna Cass and Surety Company, 119 Washington 101, 204 Pac. 1044. In referencing the basics of the whole Act rule, a Washington State Court of Appeals has stated that only one part or section does not beget an allegation. When legislative intent is at issue, the whole Act rule requires that the entire statute, not merely designated parts, be reviewed. Pratt v. Kent School District 27 WN App 375, citing Graham v. State Bar Association 86 WN 2D 624, 548 p. 2D 310, State v. Rinkas 49 WN 2D 664, 306 p. 2D 205, DeGrief v. Seattle 50 WN 2D 1, 297 p. 2D 940. In State v. Rinkas 49 WN 2D 664, 667, 306 p. 2D 205. 1957, further. Those. We set out the rules to which we are committed in construing penal statutes. Applicable here are, the legislative intent must be gleaned from a consideration of the whole Act, by giving effect to the entire statute and to every part thereof. Chapin v. Ray 59 WN 2D 459. The entireties of Titles 46, 47, and 81 RCW, are intended for and only the regulation of commercial motor carriers. Whereas every chapter, subchapter, section, subsection, paragraph and subparagraph, part and subpart of Titles 46, 47 and 8.1 is and can only be enforced on commercial enterprise. In placing a judicial construction upon a legislative enactment, the entire sequence of all statutes relating to the same subject matter should be considered. Percy Connick et al. v. City of Chehalis et al. 53 WN.2d 288, citing State ex rel. Washington Mutt. Save. Bank v. Bellingham 183 Washington 415, 48 p. 2d 609. It is our duty to construe two statutes dealing with the same subject so that the integrity of both will be maintained. Buell v. McGee 9 WN2d 84, 90, 113 p. 2d 522, 1941. The same rule applies to the construction of parts of one act. Each part must be construed in connection with every other part or section. 2 Sutherland, Statutory Construction, 3d edition, 336, Section 4703, emphasis mine. Tacoma v. Kavanaugh 45 WN2d 500, 275 p. 2d, 933. The language of a statute must be read in context with the entire statute and construed consistently with its general purpose. Wilson et al. v. Lund 74 WN.2d 945. The driver license issued by the Department of Licensing, DOL, under authority of RCW 46.25, as a species corollary to RCW 46.20, is for the conduct of business on the highways and no others. Take for example, RCW 46.72 transportation of passengers in for hire vehicles, RCW 46.72a limousines, RCW 46.73 private carrier drivers. In the case of Seattle v. Clark, 28 Washington 717, 69 Pac. 407, it was stated, every statute must be considered according to what appears to have been the intention of the legislature. It is decisive evidence of an intention to prescribe the provisions contained in the later act, as the only ones on that subject which shall be obligatory. Further, in ascertaining the purposes of the legislature, we realize it to be a fundamental rule of statutory construction that the whole act must be considered together, that each word, phrase, clause, and sentence must be considered with reference to the other words, phrases, clauses, and sentences appearing in the statute. Word. The practical inquiry is usually what a particular provision, clause, or means. To answer it, one must proceed as he would with any other composition, construe it with reference to the leading idea or purpose of the whole instrument. A statute is passed as a whole and not in parts or sections, and is animated by one general purpose and intent. Consequently, each part or section should be construed in connection with every other part or section, and so as to produce a harmonious whole. It is not proper to confine the attention to the one section to be construed. It is always an unsafe way of construing a statute or contract to divide it by a process of etymological dissection into separate words, and then apply to each, thus separated from its context, some particular definition given by lexicographers, and then reconstruct the instrument upon the basis of these definitions. 2 Lewis Sutherland, Statutory Construction, 2d edition, 706, Section 368. See, also, Seattle v. Clark, Supra, Bradley Engineering and Manufacturing Company v. Hayburn, 56 Washington 628, 106 Pac. 170, 134 AM. C 1127, Rothweiler v. Winton Motor Car Company, 92 Washington 215, 158 Pac. 737, Salo v. Pacific Coast Casualty Company, 95 Washington 109, 163 Pac. 384, L. R. A. 1917 D. 613, State v. Hillstad, 148 Washington 468, 269 Pac. 844. In Report of Seattle, 1 WN.2d 102, Infra. Emphasis mine. The businesses identified above, similarly situated, are the private class of persons required to have a driver license to operate motor vehicles for hire. To remove this class of operator, limits the license scheme to common carriers under Title 81 RCW. The whole Act rule demands respect on this issue. In determining legislative intent, with which we are here concerned, we are not limited to the provisions of the Act being construed, but may consider the general provisions of the criminal statutes. State v. Burgess, 111 Washington 537, 191 Pac. 635, 59 WN.2d 459, in the matter of the application for a writ of habeas corpus of Ben Omar Chapin v. B. J. Ray. In the usual case, if the statute's language is plain, the sole function of the courts is to enforce it according to its terms, without reference to its legislative history. United States v. Ron Parenter, Inc., 489 U.S. 235, 241, 1989, quotation omitted. This rule results from deference to the supremacy of the legislature, as well as recognition that congressmen typically vote on the language of a bill. Lamy v. United States Trustee 540 U.S. 526, 538, 2004, quotation omitted. Where the plain meaning of a statute is clear, we are not free to replace it with an unenacted legislative intent. INS v. Cardoza Fonseca, 480 U.S. 421, 453, 1987, Scalia, J., concurring. If Congress enacted into law something different from what it intended, then it should amend the statute to conform it to its intent. Lamy, 540 U.S. at 542. Further, like most principles of statutory construction, judicial deference to the plain meaning of a statute is not an absolute. One exception consists of those rare cases when a statute's plain text produces a result demonstrably at odds with the intentions of its drafters, and those intentions must be controlling. Griffin v. Oceanic Contractors Incorporated, 458 U.S. 564, 571, 1982, C. and Recolic, 328 F.3d 406, 409-10, 8th Circle 2003. Owner-Operator Independent vs. United Van Lines. United States Court of Appeals for the 8th Circuit #07-3829, 2009. The case citation directly above tells us that, on the topic of driver licenses, when RCW 46.20 etc. is read to its noticed language, there is no mention of business or commerce, when the statute says that no person may operate a motor vehicle without a license. But when one consider the case above where the court stated, when a statute's plain text produces a result demonstrably at odds with the intentions of its drafters, it means that the application of the statute affecting the right to private use of the highways is demonstrably at odds with the intent of the drafters. To conclude otherwise is to admit that the legislature intended to engage in converting a protected right into a mere privilege. The implication of the whole Act rule demands we attach RCW 46.20 etc. to all other related statutes, which includes RCW 46.25 etc. In the state's defense, and only on this point, the fact of having two separate statutes for application of a driver license is clear and convincing proof that the legislature recognizes and intended to delineate between common carriers, RCW 46.25, and private carriers, RCW 46.20, only. There is no other statute for common law travelers. For purposes of the present case, the key phrase, obviously, is relating to.
So did you hear that? There's common carriers and private carriers. There's no statute for common law travelers. Now, from their perspective, they got to try to take the high ground and, befuddle things. Well, you're driving. And here, there's the word private in here, so you're the same thing. And you're carrying passengers, so you're a carrier. You have to remember, this is if you're standing in a position where your vehicle is not registered or you remove it from their registration, you go back into being private. At that point in time, you are a common law traveler doing right to travel. Hell, you could even say you are a constitutional traveler, constitutional law traveler. I'm sure they would not like that. They already don't like the word common law. They definitely don't like private. So I'm sure they don't like the word private law traveler. And I know they don't like constitutional law. So if you were to refer to yourself as any of these, they're not going to like it. Why? Because see, whoever owns the thing, guess what? Is the owner. And if you're the owner, you get to define it. But when you register it, you stop being the complete owner. You become a business partner. And you, though you brought in the big daddy piece of chicken, you're treated as if you only brought in a wing. So why would that even make sense to do? Now we can look at it and go, why does that make sense? Why should I have registered anything with them? I'm bringing you my whole house, my whole car, my income, and you're treating it like it ain't nothing, but yet you want it. You won't let me easily pull it out of your system. You're saying I can't even govern it 100% privately at that point because it's registered to you. You won't let me reclassify it or redefine it. So I have to leave. And that's the hard part, is they don't want you to leave. Hell, some of these systems don't even have paperwork to leave them or to remove your data. What kind of fudgery is that? That's the game that they're playing. Welcome to the island of lost boys or misfit toys. Enjoy your stay. That's my evil villain laugh. I've been working on it. So now everybody wants to say I'm the bad guy in black. Well, that's fine. You dress everything else in black. Just saying. Must be something to it. Must be some power in black that can be used for good or evil. They don't want you to know that if you get your stuff right, you are common law, you are private, you are constitutional. You're the owner of the thing, you're the owner of yourself. You get to define who and what you are and the things that you own. If you don't know that and you're not in the right position, then you're in their jurisdiction. They'll make it, they will either make a claim to you and your things, or you've given them a chunk of your claim, yourself, those things. But see, the difference is that they can't fully own you. You can't fully be registered to them. Legally, you're only registering your name. The only thing that you can do to become theirs to a certain higher degree is to commit a crime or endanger other people by speeding and things of that nature. You're endangering the welfare of the general public. That allows them to supersede and to temporarily waive a chunk of your rights, freedoms, liberties, by then declaring you to be a monster, which I think was in Black Law's dictionary number 4 or 5 under human being or something. An entity to be controlled as a monster, which is a human being. Let's go.
Is relating to the. Ordinary meaning of these words is a broad one, to stand in some relation, to have bearing or concern, to pertain, refer, to bring into association with or connection with. Black's Law Dictionary, 5th edition 1979. This passage supports the district court's conclusion that the phrase related broadly bolsters exception of court. The U.S. Act, ICTA, To in the express preemption clause at 49 U.S.C. section 14501, c. 1, should be construed. The Supreme Court's statutory interpretation in Morales also. The proposition that the phrase relating to in the price preemption 49 U.S.C. section 14501, c. should be construed broadly. The Morales effectively equated the words related to and relating to, even though phrases were found in different acts, i.e., the ADA and ERISA. C 504. 383 to 86. Similarly, we should not differentiate these phrases in the especially when they are found in the same statute. It is true Morales construed relating to with regard to the breadth of preemption, not the breadth of an exception to preemption which is at issue here, but the principle is the same. Morales emphasized that statutory intent is based on the language employed by Congress and the assumption that the ordinary meaning of that language accurately expresses the legislative purpose. Citations omitted. 504 U.S. at 383. Nothing in the ordinary meaning of language suggests that cognates of relate have a broad meaning for purposes of preemption but a narrow meaning for purposes of an exception to preemption. Such a construction could only be based on a consideration other than the statutory language itself. In this regard, we note there is a general presumption against preemption of state law. See Coma Corporation v. Kansas Department of Labor, 283 Kansas 625, 632, 154.3d. 1080, 2007, citing New York State Conference of Blue Cross and Blue Shield plans. 5. Travelers Insurance Company, 514 U.S. 645, 654, 131 L, ed. 2d 695, 115 S, CT 1671, 1995. Emphasis mine. In the Court of Appeals of the State of Kansas, number 96967, State of Kansas ex rel. Phil Klein, ATT General v. Transmasters Towing and Kevin Roche, see also Independent Towers, WAV, Washington 350 F.3d 925, 9th Circle 2003. The intent of the drafters, for the basis of a driver license, is found at Pierce Code, Laws of 1919, Section 196, which code is printed herein. We then look to the latter half of the court ruling in owner-operator independent above which states, and those intentions must be controlling. This tells us that the original intent of the license statute requires the name of the business and the intended use of the vehicle. Congressional intent has been traditionally determined by an examination of the language and focus of the statute, its legislative history, and a consideration of its statutory purpose. RBEJ, Apartments Incorporated v. Gate City Savings and Loan Association, 315 N.W.2d 284, 287, ND 1982. Statutes must be construed with reference to the policy intended to be accomplished, so as to effectuate the legislative purpose which prompted their enactment. Hughes v. State Farm Mutual Automobile Insurance Company 236 N.W.2d 870, ND 1975. Northwest Airlines v. State, ex rel. Board of Equalization. 358 N.W.2d 515, ND 1984. Title 46 RCW specifically includes for hire statutes and definitions. Therefore, under the statutory construction canon expressio unius est exclusio alterius, there can be no other form of license. Licenses are issued to and for businesses. RCW 46.72, 010, definitions, 1, reads in relevant part. The term for hire vehicle includes all vehicles used for the transportation of passengers for compensation. It is a general principle of interpretation that the mention of one thing implies the exclusion of another thing, expressio unius est exclusio alterius. 25 Arg. C. L. 981, Section 229. In North Point Consolidated Company v. Utah and S. L. Canal Company, 14 Utah 155, 46 Pac. 824, the court made this statement. Is the maxim, expressio unius est exclusio alterius, is usually applied to determine the intention of the lawmaker where it is not otherwise expressed, and applicable to constitutional or statutory provisions which grant originally a power or right. When a statute defining an offense designates but one class of persons as subject to its penalties, all other persons are deemed to be excluded. Further, as a general rule, the expression of one thing in a constitution or statute excludes all others. So specific provisions, relating to particular subjects, must govern in relation to that subject, as against general provisions in other parts of the law which might otherwise be broad enough to include it. Where a statute enumerates the persons or things to be affected by its provisions, there is an implied exclusion of others, and the natural inference follows that it is not intended to be general. Emphasis. Mine. The State of Washington, on the relation of the Port of Seattle v. the Department of Public Service et al. 1 WN.2 D102. What follows here is a gathering of research on the whole Act rule, which is reverently succinct as to the commands and dictates of reading policies in peri materia, from legislative conception to judicial rendering. This writer finds no need, as holding self-indicting, to expound on, neither narrate, these rules further. Legislative inclusion of certain items in a category implies that other items in that category are intended to be excluded. Boer v. Johnson, 122 WN2 D 829, 836, 864 p.2 D 380, 1993. Where a statute specifically designates the things or classes of things upon which it operates, an inference arises in law that all things or classes of things omitted from it were intentionally omitted by the legislature under the maxim expressio unius est exclusio alterius specific inclusions. Exclude. Implication. Emphasis mine. Washington Natural Gas Company v. Public Util. DIST number 1. 77 WN2 D94, 459 p.2 D 633, 1969. Under the expressio unius est exclusio alterius canon of statutory construction, the expression of one thing in a statute implies the exclusion of the other. State v. Delgado, 148 WN.2 D 723, 63 p.3 D 792, 2003, citing in Re Detective of Williams, 147 WN.2 D 476, 55 p.3 D 597, 2002. In ascertaining the purposes of the legislature, we realize it to be a fundamental rule of statutory construction that the whole act must be considered together, that each word, phrase, clause, and sentence must be considered with reference to the other words, phrases, clauses, and sentences appearing in the statute. The practical inquiry is usually what a particular provision, clause, or word means. Further. To answer, one must proceed as he would with any other composition, construe it with reference to the leading idea or purpose of the whole instrument. A statute is passed as a whole and not in parts or sections, and is animated by one general purpose and intent. Consequently, each part or section should be construed in connection with every other part or section, and so as to produce a harmonious whole. State ex rel Port of Seattle v. Department of Public Service 1 WN2 D 102. In construing a statute and ascertaining the legislative intent, certain rules are observed by the courts. The legislative intent must be gleaned from a consideration of the whole act by giving effect to the entire statute and every part thereof. Hauk supra, citing Lynn v. Reed, 114 Washington 609, 196 Pac. 13, State ex rel. Baston v. Preston, 151 Washington 175, 275 Pac. 81, Pease v. Stevens, 173 Washington 12, 21 p. 2D, 294, Arden Fair Company v. Seattle, 2WN, 2D, 640, 99 p. 2D, 415, State Ex Rel. Wilson v. King County, 7WN, 2D, 291. Language within a statute must be read in context with the entire statute and construed in a manner consistent with the general purposes of the statute. A learned writer has explained, the presumption is that the lawmaker has a definite purpose in every enactment and has adapted and formulated the subsidiary provisions in harmony with that purpose, that these are needful to accomplish it, and that, if that is the intended effect, they will, at least, conduce to effectuate it. That purpose is an implied limitation on the sense of general terms, and a touchstone for the expansion of narrower terms. This intention affords the key to the sense and scope of minor provisions. From this assumption proceeds the general rule that the cardinal purpose or intent of the whole act shall control, and that all the parts be interpreted as subsidiary and harmonious. Wilson v. Lund 74 WN 2D 945. Where the language of a statute is plain, free from ambiguity, and devoid of uncertainty, there is no room for construction because the meaning will be discovered from the wording of the statute itself. Hauk Supra, citing Shelton Hotel Company v. Bates, 4WN, 2D, 498, 104 p. 2D, 478. Where an act has a doubtful or ambiguous meaning, it is the duty of the court to adopt a construction that is reasonably liberal in furtherance of the obvious or manifest purpose of the legislature. Hauk Supra, citing Othis v. Causer, 119 Oregon 101, 248 Pac. 146, Gallagher v. Campodonico, 121 calories, App. 765, 5 p. 2d. 486. Under this approach, it is appropriate for a court to give, and did the Court Appeals, a non-technical statutory term its dictionary meaning. We have, however, recently indicated that the plain meaning of a statute may be discerned from all that the legislature has said in the statute and related statutes which disclose legislative intent about the provision in question. Depth of Ecology v. Campbell and Gwynn, LLC, 146 WN.2D1, 11, 43 p.3D4, 2002. Under this approach, we construe the Act as a whole giving effect to all of the language used. We stated that this formulation of the plain meaning rule provides the better approach because it is more likely to carry out legislative intent. Thurston County v. Cooper Point Association 148 WN2D1. We emphasize that W.E. read the plain language of the statute as a whole, and interpret its provisions in harmony with other statutes in the same chapter and related chapters. Miller v. Weaver, 2003 UT 12, 17, 66 p.3d 592, emphasis added. In so doing, we adhere to the cardinal rule that the general purpose, intent, or purport of the whole act shall control, and that all the parts be interpreted as subsidiary and harmonious to its manifest object. ID. Citations omitted. Therefore, to avoid interpreting the statute in a piecemeal fashion, we interpret the terms of the Act as a comprehensive whole. Business Aviation of SD, Inc. v. Medivest, Inc. 882 p.2d 662, Utah 1994. Generally, the first step a court takes when reviewing the meaning of a statute is to look into the plain meaning of its terms. State v. Germestad 114 WN.2d 828, 791 p. 2d 897, 1990. It is too well established to need citation of authority that a court may not place a narrow, literal, and technical construction upon a part only of a statute and ignore other relevant parts. In the process of construction, the intention of the lawmakers must be extracted from a consideration of all of the provisions of the Act. DeGrief v. City of Seattle 50 WN2D1. Citing in Recress, 13 WN, 2D, 7, 123 p. 2D, 767. See also Commercial Waterway District Number 1 of King County v. Permanente Cement Company 61 WN2D 509. It is a familiar canon of construction that when similar words are used in different parts of a statute, the meaning is presumed to be the same throughout. De Grief Supra, citing Buma v. Bigelow Sanford Carpet Company, 330 Massachusetts 79, 111 NE, 2D, 742, and cases cited. Courts should interpret a statute with an eye to the surrounding statutory landscape and an ear for harmonizing potentially discordant provisions. United States v. Base 404 U.S. 336, 344, 1971. Indeed, even in the context of sentencing provisions in penal statutes, a single phrase should not be construed in isolation from the statutory scheme as a whole when to do so would result in a meaning that contradicts or distorts the fair import of the whole remaining language. United States v. Brown, 333 U.S. 18, 25-26, 1948, c. e.g., United States v. Campos Serrano, 404 U.S. 293, 298, 1971, United States v. Base, Supra, 404 U.S. at 350-351. Further, the rule of lenity is merely a guide to statutory construction. Callanan v. United States, 364 U.S. 587, 596, 1961, which is not applicable unless there is such a grievous ambiguity or uncertainty in the language and structure of the Act. Huddleston v. United States, 415 U.S. 814, 831, 1974, that even a court has, says, said, everything from which aid can be derived *****, it is still left with an ambiguous statute. United States v. Base, Supra, 404 U.S. 347, quoting United States v. Fisher, 6 U.S., 2 Cranch, 358, 386, 1805. As this court observed in United States v. Moore, 423 U.S. 122, 125, 1975, quoting United States v. Brown, 333 U.S. 18, 25-26, 1948. The canon in favor of strict construction of criminal statutes is not an inexorable command to override common sense and evident statutory purpose *****. Nor does it demand that a statute be given the narrowest meaning. It is satisfied if the words are given their fair meaning in accord with the manifest intent of the lawmakers. See also, e.g., United States v. Naftalin, 441 U.S. 768, 778-779, 1979, United States v. Colbert, 435 U.S. 371, 379, 1978, Scarborough v. United States, 431 U.S. 563, 577, 1977, Iannelli v. United States, 420 U.S. 770, 789, 1975, ID. At 795, Douglas J., dissenting, ID. At 798, Brennan, J., dissenting, United States v. Moore, 613 F.2d 1029, DCCIR 1979, cert. Denied, 446 U.S. 954, 1980. Moreover, as this court noted in United States v. Colbert, Supra, 435 U.S. at 379, the rule of lenity applies only when a statute is genuinely ambiguous, or uncertainty exists as to Congress's intent. Further, the rule of lenity, which should only be utilized when a court's ***** interpretation can be based on no more than a guess as to what Congress intended. Befulco v. United States, Supra, 447 U.S. at 387. It should not be used to directly contradict legislative intent or to reach what the Second Circuit correctly characterized as an anomalous result. United States v. Rossetti Brothers, Supra, 671 F.2d at 720. United States of America v. RSR Corp. In the Supreme Court of the United States October Term, 1982, number 82-491. The Solicitor General, on behalf of the United States of America, petition for a writ of certiorari to the United States Court of Appeals for the Fifth Circuit. A court should presume that every word has some meaning, and avoid rendering any word nugatory. Tiger Stadium Fan Club, Inc. v. Governor, 217 Michigan App 439, 457, 553 NW2D. Legislative intent is to be found in the terms and arrangement of the statute without straining or refinement, and the expressions used are to be taken in their natural and ordinary sense. Gross v. General Motors Corp., 448 Michigan 147, 160, 528 NW2D 707, 1995. The primary goal of statutory interpretation is to ascertain and give effect to its legislative purpose. Hayworth, Inc. v. Wicks MFG Co., 210 Michigan App 222, 227, 532 NW2D 903, 1995. The language of the statute itself is the primary indicator of legislative intent. Follens Jewelry Brokers, Inc. v. City of Warren, 210 Michigan App 304, 307, 532 NW2D 920, 1995. If the plain and ordinary meaning of the statute is clear, judicial construction is normally neither necessary nor permitted. Department of Transportation v. Thrasher, 196 Michigan App 320, 323, 493 NW2D 457, 1992, aft. 446 Michigan 61, 521 NW2D 214, 1994. The title or caption of an act may be properly considered to aid in the construction of a statute and to show the intent of the legislature. C. Lindsay v. Southern Farm Bureau Cass. Inns Company, 258 SC 272, 188 S.E.2D 374, 1972. When interpreting the meaning of a statute, certain basic principles must be observed. The cardinal rule of statutory interpretation is to ascertain and give effect to legislative intent. State v. Martin, 293 SC 46, 358. S.E.2D 697, 1987. Typically, legislative intent is determined by applying the words used by the General Assembly in their usual and ordinary significance. Martin v. Nationwide Mutual Insurance Company, 256 SC 577, 183 S.E.2D 451, 1971. Resort to subtle or forced construction for the purpose of limiting or expanding the operation of a statute should not be undertaken. Walton v. Walton, 282 SC 165, 318 S.E.2D 14, 1984. Courts must apply the clear and unambiguous terms of a statute according to their literal meaning, and statutes should be given a reasonable and practical construction which is consistent with the policy and purpose expressed therein. State v. Blackman, 304 SC 270, 403 S.E.2D 660, 1991, Jones v. South Carolina State Highway Department, 247 SC 132, 146 S.E.2D 166, 1966. Rules of construction are but guidelines by which to arrive at legislative intent and must be applied with care and with due regard to common sense. A study not only of the rule but the cases applying them and attention to the purpose of Congress. Prior tariff acts, background information, and legislative history are important in this area. L.R. Markel et al. v. United States, 16 CT Cust Apples. 518, TD 43239, 1929. It is a primary function of the courts to determine legislative intent. United Metal Goods Manufacturing Company vs. United States, 46 CCPA 120, CAD 712, 1959, United States vs. S.H. Kress and Company, 46 CCPA 135, CAD 716, 1959. The first source for the determination of that intent is the statutory language, which is presumed to be used in its normal sense. United States vs. Esso Standard Oil Company, 42 CCPA 144, 151, CAD 587, 1955, United States v. British Cars and Parts Incorporated, et al., 47 CCPA 114, CAD 741, 1960, John S. James A.C. The Consolidated Packaging Corporation v. United States, 48 CCPA 75, CAD 768, 1961, United States vs. Gulf Oil Corporation et al., 47 CCPA 32 CAD 725, 1959. It is the duty of the court to adopt the rule of construction which will give effect to the intention of Congress as ascertained. United States vs. American Express Company, 2 CT Cust Apples. 95, TD 31636, 1911. Results. In the presence of ambiguity in a statute, the fact that inconsistent or absurd may flow from one construction and not another will often lead the court to adopt the latter as most likely expressing the legislative intent. Cohen and Rosenberger vs. United States, for CT Cust Apples. 378, 383, TD 33536, 1913, Spencer Importing and Trading Company v. United States, 2 CT Cust Apples. 444, TD 32201, 1912. A possible ambiguity in the first part of an act may be resolved when the entire statute is read and considered. Border Brokerage Company vs. United States, 27 Cust CT 223, 227 to 228, CD 1375, 1951, Aft 40 CCPA 185, CAD 515, 1953. It is well established that in the construction of a statute the intention of the legislature is to be deduced from the whole statute and every material part of the same. The entire context must be considered and every effort made to give full force and effect to all the language contained therein. United States vs. Invicta Sealand Incorporated, 25 CCPA 300, 305, TD 49397, 1938, Dart Export Corporation et al. v. United States, 43 CCPA 64, 74, CAD 610, 1956, United States vs. Gulf Oil Corporation et al., 47 CCPA 32, 35, CAD 725, 1959. See generally Heidi on Automobiles 9th ed., Section 249 footnote 63. Shuttlesworth vs. City of Birmingham, 394 U.S. 147, 1969, 89s. CT 935 Can RCW 46.20 be definitively narrowed to succinctly and specifically identify the differing aspects of private and the authority of the state when a person hires out his personal automobile? No. The object rule of substantive notice is to be plainly posted for a person of average intelligence to understand. The rule does not provide any latitude for the state to fragment chapters, which clearly have a causal link to the primary intent and purpose of the regulation, which would tend to force an affected person not to suspect that there are volumes more relevant and pertinent information on the requirements of a driver license. In considering the offer and acceptance practice that is the fundamental basis of commerce, when the state proffers a claim aka charge, civil or criminal, it is the state's burden of proof to show that in fact there was a commercial act to effect their claim. If the state, in their enforcement proceedings, cannot show commercially that personal affairs falls within the reach of the questioned policy, the policy does not provide notice of whether or not private conduct falls within the prescript of the legislative intent. The state is equally bridled with, in consideration of the foregoing paragraph, the burden of showing that there was an attempted solicitation to hire out. As a general rule of construction, the plain language of the statute will prevail in the absence of evidence of a contrary legislative intent. 4. Only when the meaning of the language is unclear will the court resort to the recitals in or title of a statute to ascertain the intent of the legislature. 5. However, it is a fundamental principle that statutes should be construed to effectuate the legislature's intent. 4. C. E.g., City of Miami Beach vs. Galbot, 626 So. 2D 192, Flaw 1993, where statute is clear and unambiguous, court will not look behind statute's plain language for legislative intent. Cohen vs. Florida Department of Law Enforcement, 654 So. 2D 1058, Flaw 1st DCA 1995, where language of statute is unambiguous, statute should be accorded its plain and ordinary meaning. 5. See generally, 82 CJS Statutes SS 349 and 350. Attorney General Advisory Legal Opinion AGO 96-57, July 19, 1996 Robert A. Butterworth Florida Attorney General. The History and Theory of Statutory Interpretation. A book, authored/compiled by William D. Popkin. Does the current statute give fair notice of the intent of the statute? Does the current statute give fair notice of the subject regulation? Does the current statute give fair notice of preventative restrictions that a policy enforcement employee would trespass against private travels and arbitrarily enforce public business standards? Does the current statute provide notice of the state's competing or compelling interest? Reflecting on the questions above, here is a portion of an intake orientation from a prominent law school, also reflecting the breadth of this writing. Statutes in derogation of the common law should be strictly construed. The rule of lenity, criminal statutes should be narrowly construed. Special statutes trump general statutes. Georgia State University College of Law, Orientation Notes on Statutory Interpretation. Commercial purposes on the highways in the transportation of passengers and property or cargo. Emphasis mine. The curriculum of law schools is expressed throughout this writing. As indicated above, the law school presents that special statutes trump general statutes, and that particular words trump general words. The same theory of law was expressed in the policy intent by the Washington State Legislature at RCW 46.25.005 as follows. To the extent that this chapter conflicts with general driver licensing provisions, this chapter prevails. The special commercial motor vehicle provisions of 46.25 trump and prevail over the general license proviso of 46.20. That is proof positive that all licenses are in fact commercial. The following case law is introduced to influence thought as to the entire application of the Motor Vehicle Act. The following case is a good example for a criminal traffic infraction. Can a person be charged with, for instance, driving under the influence while traveling privately? No. Why? Initially, because the rule of preemption dictates that federal statute prevails. That is important here because federal statute only regulates commerce. Secondly, state statute has already admitted to be predicated on the federal statute. Thirdly, as and for commercial consideration, with respect to the rule of lenity and the following rule of severability, the DUI and DWI statutes were passed subsequent to the initial licensing act. So, speaking to these rules means that, according to the rule of lenity, to strictly construe a DUI statute is to make it only applicable to drivers of businesses, thusly, to the rule of severability below, if we're able to delete from the state's police power and regulation the licensing provisions. Would then the state have the ability to charge a person with a DWI under motor vehicle laws? No. It also runs counter to the constitutional requirement that the prosecution must prove every element of its case beyond a reasonable doubt. In Re Winship, 397 U.S. 358, 363, 90 S, CT 1068, 25 L, ed. 2D 368, 1970, State v. Roberts, 88 WN 2D 337, 340, 562 p.2 D 1259, 1977. Further. More. 1. Quoting. An act of the legislature is not unconstitutional in its entirety because one or of its provisions is unconstitutional unless the invalid provisions are unseverable, and it cannot reasonably be believed that the legislature would have passed the without the other, or unless the elimination of the invalid part would render the remainder of the act incapable of accomplishing the legislative purposes. State v. Anderson 81 WN 2D 234, 236, 501 p.2 D 184, 1972. State v. Crediford 130 WN.2 D 747, 927 p.2 D 1129. The following case, while not factually adjunct to this discussion, in the first half, reasons those who actually benefit from the business license granted by the state have no justification for complaint. In contrast, it further reasons, in the latter half, that the state ought not bootstrap private travel under public law. The U.S. Supreme Court phrase "the Equal Protection Clause" requires more of a state law than non-discriminatory application within the class it establishes, stated in the case below. When placed juxtapose the Washington legislature's own language, it is intended that this 1965 Amendatory Act be liberally construed to effectuate the purpose of improving the safety of our highways through driver licensing procedures within the framework of the traditional freedoms to which every motorist is entitled. SB 334, 1965, galvanizes the utilitarian aspect of highways, as secondary to the primary private use classification. Yet the fact that all those not benefited by the challenged exemption are treated equally has no bearing on the legitimacy of that classification in the first place. A state cannot deflect an equal protection challenge by observing that in light of the statutory classification all those within the burdened class are similarly situated. The classification must reflect pre-existing differences. It cannot create new ones that are supported by only their own bootstraps. The Equal Protection Clause requires more of a state law than non-discriminatory application within the class it establishes. Rinaldi v. Yeager, 384 U.S. 305,308, 1966. Emphasis mine. Williams v. Vermont 472 U.S. 14, 1985. Washington statutes are no different in intent and content than what is discussed of Florida and Kansas herein. Why? Because of the Uniform Vehicle Code, which was implemented nationwide after several years of discussion and evolution. This was as much admitted by the Washington State Legislature, Senate Bill No. 334, 1965. An act relating to motor vehicle driver licensing. Purpose Construction 1965 XS. C 121 Section 1. With the advent of greatly increased interstate vehicular travel and the migration of motorists between the states, the legislature recognizes the necessity of enacting driver licensing laws which are reasonably uniform with the laws of other states and are at the same time based upon sound, realistic principles, stated in clear explicit language. To achieve these ends, the legislature does hereby adopt this 1965 Amendatory Act relating to driver licensing modeled after the Uniform Vehicle Code, subject to such variances as are deemed better suited to the people of this state. It is intended that this 1965 Amendatory Act be liberally construed to effectuate the purpose of improving the safety of our highways through driver licensing procedures within the framework of the traditional freedoms to which every motorist is entitled. Emphasis mine. Take note of the emphasis directly above. First, this act is amendatory, not newly created. Secondly, notice the phrase "within the framework of the traditional freedoms to which every motorist is entitled." In 1965, the Washington State Legislature acknowledged we have the free use of the public roads, and the legislature designed the commercial aspect to be within, not to replace that freedom. What Washington statutes have done is to dilute the clarity of express language, appealing to the supposed necessity of the driver license, and has concealed the concept of the free and unmolested use of the highways by the general public, and openly enforced, by statute, the highways only as a place of business, bootstrapping the government's alleged compelling interest to regulate travel. That spurious maneuver has divided its intent amongst no less than 4 statute titles, 2 administrative code sections, and the myriad related chapters, with dizzying plausible effects so that the average individual could not possibly, without the aid of the whole Act rule, the rule of exclusion, the rule of lenity, bootstrapping, and the rule of statutory construction, expressio ionius est exclusio alterius, and the equity rule nullum simile est idem, discern the purpose and intent of not only the state's jurisdiction and authority to regulate and control the roads, but also the federal government's original issue intent of and for the highway system, not to detract from the legal definition of the term highway. Anyone can pick up the Revised Code of Washington, currently, look to Title 46, and find what 99% of police and lawyers know to be the policy laws of conduct upon the highways. This is not to suggest the police are not aware of personal private travel. Beginning in 1915, the statute codes of Hill, Ballinger, Remington, and Pierce as and with their amendments, were slowly absorbed by amendment, or simply repealed, to be rewritten into what was enacted in 1919 to be an exclusive title for vehicle codes. Pierce Code at Section 196, Laws of 1919, states that this act is now conclusive. Meaning, it is now a comprehensive conclusive statute of vehicle codes, over what had been a mere few sporadic codes previous. Not to discount any of the several amendments to Title 46, the focus of this writing is with the origins of the State Motor Vehicle Acts back to the turn of the century, 1900, with select curiosities. First, here, for discussion only, discounting repeal, we find that a vehicle on the public roads with an expired registration, tabs, or without a valid driver license is a nuisance. Therefore, the individual has damaged the state. What do nuisances create? Tort liability. Pierce Code Circ 1902, Chapter 73. Offenses against public policy. Amendatory, and ACT relating to nuisances, amending Section 118 of the Penal Code, C8I Section 898, contained in Hill's Annotated Statutes and Codes of Washington. Approved March 2, 1895. Laws 95 p. 21. Section 1741. Doing business without license. Section 900, 137. Every person who shall, by himself or agent, transact any business, or do any act, without a license, therefore, where such license is required by any law in this state, shall, on conviction thereof, be fined in any sum not exceeding $500, and in all such cases where the principal is prosecuted, his agent may be compelled to testify, and when the agent is prosecuted, the principal may be compelled to testify. B.C. Section 7311, 2H. P.C. Section 132. Emphasis mine. In 1903, the legislature passed a law, in so accepting federal highway grants, funds, that the free use of the highways shall be maintained, and as such, not cause impediment to travelers. Session Laws, 1903, Chapter 103. HB Number 424, empowering boards of county commissioners to accept rights of way for construction of public highways. Be it enacted by the legislature of the state of Washington, Section 1. The boards of county commissioners in their county commissioners' respective counties in this state are hereby authorized and empowered to accept the grant of rights of way for the construction of highways over public lands of the United States, not reserved for public uses, contained in Section 2477 of the Revised Statutes of the United States. Provided that nothing herein contained shall be construed to invalidate the acceptance of such grant by general public use and enjoyment, heretofore or hereafter had. Emphasis mine. Remember that pursuant to, and with accommodation of, the whole Act rule, all statutes relating to a particular scope are considered in the interpretation of the intent of the policy. See Washington Constitution Art. 12 Section 15 for similar language. Session Laws, 1911. Ch. 117. Article 2. Provisions relating to common carriers. SEC 9. Charges, duties of common carriers. All charges made for any service rendered or to be rendered in the transportation of persons or property, or in connection therewith, by any common carrier, or by any two or more common carriers, shall be just, fair, reasonable and sufficient. Every common carrier shall construct, furnish, maintain, and provide safe, adequate and sufficient service facilities, trackage, sidings, railroad connections, industrial and commercial spurs arid equipment to enable it to promptly, expeditiously, safely and properly receive, transport and deliver all persons or property offered to or received by it for transportation, and to promote the safety, health, comfort and convenience of its patrons, employees and the public. All rules and regulations issued by any common carrier affecting or pertaining to the transportation of persons or property shall be just and reasonable. Sector 10. Duty of carriers and persons to expedite traffic. Every common carrier shall under reasonable rules and regulations promptly and expeditiously receive, transport and deliver all persons or property offered to or received by it for transportation. So in consideration of all previous citations, court rulings, and implications of commerce whether public or private, we have the first, as near, complete collection of statutes under a single act for motor vehicles. Restated here, by and with the author's excision of dictum matters. Pierce Code, Laws of 1919, Section 196. Automobiles. And ACT relating to the use of the public highways. Section 196. Act conclusive. Or. Determined. Provided. Such shipping. Section 200. Application for license. Showing to be made. The application must show, 1. The name of the owner, with the business or residence address thereof, or both if there be such, 2. The nature of the license required, whether a license has heretofore been issued for such vehicle, and if so, the number of such license, 3. The trade name of such vehicle, the factory number thereof and the name and address of the manufacturer, 4. The kind of vehicle, whether a motorcycle, automobile, auto stage, auto truck or other motor vehicle, 5. The rated carrying capacity of such vehicle, 6. The purpose for which the same is to be used, and whether for public, private use, if for public, the nature of the same in the city or community to be served, 7. The power to be used, whether electric, steam, gas or other power, 8. The weight of all automobiles for private use which shall be by the shipping weight thereof is given by the manufacturer. However, that if the Secretary of State is unable to obtain weight on any particular make or model of automobile, he may by general time prescribe thereof by certificate application for license of state and the owner of the italic mine. Rules and regulations adopted and published from time to the method of ascertaining such weight and the proof affidavit or otherwise which shall accompany the when the same is forwarded to the Secretary. Vehicle shall pay. Section 207. Number plates. Section 12. The Secretary of State may put such other mark or character on such plates, to properly identify the kind of license issued. Section 228. Arrests by peace officers. Section 32. Any peace officer may make arrests for any violation of this act with or without warrant therefor upon showing his authority as such officer, and for the purpose of enforcing the provisions of this act the Secretary of State, or his appointed deputies shall be deemed peace officers and shall have the same power and authority as any peace officer within the county, city or town in which such violation occurs. Emphasis mine. Section 230. Restrictions on local authorities. Section 34. The local authorities shall have no power to pass or enforce any ordinance, rule or regulation governing the speed of any motor vehicle in conflict with the provisions of this Act or requiring of the owner or operator of any motor vehicle any license other than an occupation. License, when such motor vehicle is engaged in intercity service.
Whoa. Local authorities, police officers shall have no power to pass or enforce any ordinance, rule, or regulation governing the speed of any motor vehicle in conflict with the provision of this Act, or requiring of the owner or operator of any motor vehicle any license other than an occupational license. So what they did was they combined a regular license with the driver's license, making the license an occupational one. This is why you can take it and become like a bus driver, Uber, DoorDash, because it's a merger. Whereas once there was just a regular license, now they've made it so that it's occupational. They've combined it. And in that, they've muddied it and dirtied it to give them the ability to bother you, not just if you are doing an occupation.
Service provided. However, that nothing herein shall be construed as limiting the power of the county commissioners or local authorities to make, enforce, and maintain ordinances, rules and regulations governing traffic in addition to the provisions of this Act. Affecting motor vehicles, but not in conflict therewith. Emphasis mine. Section 235. Permits for automobiles as passenger carriers. Section 1. It shall be unlawful for any person, firm or corporation, to engage in or carry on the business of carrying or transporting passengers for hire in any motor-propelled vehicle along any public street, road, or highway, provided, engaging in the business of transporting passengers for hire in any motor-propelled vehicle, shall come under the provisions of this Act. Emphasis mine. The following section is added to this reading to show that statute code is only prima facie evidence of law, policy. The following excerpt is the legislative enactment from 1919. Notice how the legislative language differs from the preceding statute section 200, paragraph 8. Session Laws, 1919. Chapter 59. SEC.5. The owner of any such automobile when making application for license thereon shall cause said vehicle to be duly weighed upon a public scale and attach the certificate of weight to his application for license, which certificate must accompany such. We find an admitted acknowledgement from the state that the Motor Vehicle Act is commercial. Pierce, Washington Code Circ. 1921, Automobiles, Common Carriers, Section 234-10. Application Intrastate. Section 8. Neither this Act nor any provision thereof shall apply or be construed to apply to commerce with foreign nations or commerce among the several states of this Union except in so far as the same may be permitted under the provisions of the Constitution of the United States and the Acts of Congress. Emphasis mine. Prior to 1921, the Office of the Secretary of State would receive applications for motor vehicle business license. However, in consideration of the rapid growth and popularity of the motor vehicle, replacing horses to transport their freight and passengers, this became a burden on the Secretary's office. Thusly, the Washington State Legislature created a separate department to handle the massive influx of applications. Can the Department of Licensing issue any kind of license that isn't a business? No. As shown in and of the numerous, consistent, non-conflicting court rulings, use of the public highways as a place of business and profit is separate and distinct from that of the common traveler. As seen above in the legislative enactment, the following excerpt is proof positive that a license is for business, and only for those who use the public roadways for purpose of that business. The word license wherever used in the succeeding sections shall be held and Construed to mean, authorizing the practice of a profession or calling, the carrying on of a business or occupation. Session Laws, 1921. Chapter 7. H.B. 11, Administrative Code. Be it enacted by the Legislature of the State of Washington. Section 1. This act shall be known and may be cited as the Administrative Code. SEC 2. There shall be, and are hereby created, departments of the state government which shall be known respectively as 9. The Department of Licenses. SEC 98. The word license wherever used in the succeeding sections shall be held and construed to mean and include license, certificate of registration, certificate of qualification, certificate of competency, certificate of authority, and any other instrument, by whatever name designated, authorizing the practice of a profession or calling, the carrying on of a business or occupation, or the doing of any act required by law to be authorized by the state. Review above, Pierce Code, Laws of 1919, Automobiles. Section 200. Application for license. Note the differences in legislation here now below in 1921. This language is implicated again in 1937 and 1947. Below, there is no longer the term business in subsection 1, as was previous, because the state has unilaterally assumed that the owner of the vehicle business is the person making application, and therefore must both be at the same address. Secondly, the request for the purpose of the license in subsection 4, to determine whether the vehicle is used to transport persons, property, or freight. Subsection 5 shows the requirement to disclose the adult seating capacity of the vehicle for purposes of transporting passengers. The remainder of this title discussion on motor vehicle weights is primarily for haulers, who transport goods and property at a scale weight. However, it is noteworthy that all pickup trucks and some SUVs pay a tonnage excise tax when the yearly tabs are renewed, which classifies and qualifies them as commercial freight haulers, irrespective of whether that commerce is public or private. The application must show 1. Name and address of the owner of the vehicle. _________. 2. Trade name of the vehicle, the model, year, type of body, factory number and motor number thereof. 3. The power to be used, whether electric, steam, gas or other power. 4. The purpose for which said vehicle is to be used and the nature of the license required. 5. The rated carrying capacity of such vehicle, which in cases of auto for hire, auto stages, or auto stage trailers shall be the adult seating capacity thereof, and in cases of motor trucks or trailers shall be the rated capacity load as given by the manufacturer. In 1923, the legislature once again makes a published admission that there is a separate and distinct difference between those who operate motor vehicles as a business on the public highways and the common traveler. In one enactment, the legislature has distinguished vehicle, motor vehicle, and other. Session Laws, 1923, Chapter 122, S.B. 267. Motor Vehicles. An act relating to the operation of vehicles and the use of public highways, providing for the licensing of persons operating motor vehicles, providing for the enforcement thereof and all other highway and motor vehicle laws and prescribing penalties for violations thereof, and amending Section 234-22 of Pierce's Code, and adding a new section. Mine. Be it enacted by the Legislature of the State of Washington. Emphasis. SEC 2. That a new section be added to Sector 234-22 of Pierce's Code, to be known and designated as Sector 234-22A, to read as follows: Sector 234-22A. It shall be unlawful for any person to drive a motor vehicle in a reckless manner over and along the public highways of this state. For the purpose of this section, to drive in a reckless manner shall be construed to mean the operation of a motor vehicle upon the public highways of this state in such a manner as to endanger or inconvenience unnecessarily other users off such highway. Any person found guilty of a violation of this section shall be guilty of a misdemeanor, and the court may in his discretion suspend the operator's license for a period of time not to exceed 6 months. Emphasis.
Now that right there is an interesting thing, because for some of you guys who've lost your licenses and come to me, have you read your state's constitution? Have you read your state's legislative codes? Because in this one, it says not more than 6 months. I'm just saying, you got to start reading and going after them. And not only just reading this to beat your case, but suing them over this. Hold them to the line, good sir. If they've done this to you, use this to beat your case, but then also sue them over it. The damage has already been done. We need to hold them so tight to the letter of the law that we get our freedoms, rights, and liberties back, and they're afraid to encroach, infringe, or abridge them.
Emphasis mine. By 1937, motorized automobiles had been around for near 30 years. So, what is the difference though between an automobile, a vehicle, and a motor vehicle? As it is defined by federal law, a motor vehicle is, while not distinguishing types, a publicly available commercially applied vehicle. A vehicle, however, is a private not for public use vehicle. Although a private vehicle is still commercially engaged because it is employed in the private business sector. This distinction was clarified by the Washington State Legislature as follows. Session Laws, 1937, ch. 188. SEC 29. The application must show 2. Trade name of the vehicle, model, year, type of body, the motor number thereof if such vehicle be a motor vehicle, or the serial number thereof. If such vehicle be a trailer.
If such vehicle be a trailer. Guys, the devil's in the detail. The devil's in the detail. All right, guys. This is part 3. I think I'm gonna shoot one more part. Then there might be one more, so it might be 5 parts in total. Looks like. A lot of work went into this from all the people who participated. So shot goes out to all of the nationals, all of the Americans, all the people out there who had anything to do with all this, all the lawmakers, the good ones, and including the people in municipalities, law enforcement, whatever else, who are on the right side as Americans. Not you evil international scum-sucking horde making us fight amongst ourselves, even as nationals, because you got some of our sick brothers out there wanting to fight, even though we're the same color. Americans out here wanting to fight because they don't understand that there's a difference between a U.S. citizen and a national per 8 FAM, section 301.1, difference between citizenship and nationality not being the same thing in the United States of America. But I digress. Some of y'all might be mad at the change in the establishment, this, that, and the other. And as always, there's always going to be some collateral damage. But what I will tell you is this. It is always darkest before the dawn. And in order for us to go from where we are, which is really quite astonishing that people out there are mad at people for the change. It's like some of you guys have Stockholm syndrome, where you've begun to identify with your abuser and your oppressors. Just like Morpheus said in the Matrix. Some people are still plugged into the Matrix. Just like I'm making my TikTok videos. Some of you guys are still so feral, you don't even realize you're feral. Still so sucking the DICK of the system and don't even realize it. But you want to be mad at people like me, people who bring change. Things have to change in order to get better. If you like your crummy little dirty cell, then stay in there. No one's telling you have to come out. We just don't want to hear about it. You want to complain that other people want to have their rights and freedoms and liberties that they were given by God, protected and enforced by the Constitution, Supreme Court, and good enforcement officers out there. That you would prefer to fight me or people like me to stay in your ignorance. Well, I'm sorry. I'm not here to be complicit with evildoers and victims who now sympathize with their captors, who learn to love their pain. The majority of people have spoken. It begins then.